Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration questions. So, I have a great topic for you. And the topic today is the process of applying for a green card, even when you're out of status. Now, there are a number of people in the United States who may be out of status, and you're trying to figure out how to fix that situation to still go on and get your permanent resident. And there are a number of options available, but you still do have to meet very specific criteria to be able to apply for those. And I'm going to give you a quick and dirty summary of what you will need to do if you're out of status, some of the ways that you can fix that and still go on to get permanent residence. Now, often I'll get the question as to whether your employer can file for you if you're out of status. And the answer is it depends. Under most circumstances, no. Generally, you have to be maintaining legal status in order and not working without a permit in order to adjust status to get your employment-based green card while being in the United States. However, if you do have a U.S. citizen or legal permanent resident, spouse, or parent, and you're out of status, an employer may be able to sponsor you, still apply for you, and you may be able to get a waiver to forgive the overstay and still go on to get your residence through your employer. But this is likely going to result in you doing consular processing. So it's called the waiver and consular process, where you still have to leave the US at some point to finish your green card process. But that's one way if you're out of status. Now, otherwise, you would not likely qualify for employment if you're out of status. However, under family-based immigration and humanitarian-based immigration, there are still ways to fix the situation if you qualify for those. So first, under family, if you're the immediate relative of a U.S. citizen, that means you're the spouse of a U.S. citizen, you're the parent of a U.S. citizen, and that U.S. citizen is 21 or up, or you are the son or daughter of a U.S. citizen, and you're under 21 and unmarried, you qualify as an immediate relative of a U.S. citizen. And if you entered the country with permission, you were inspected at the border in some way, you came in with a visa, even if that has now expired, even if your stay has now expired, you can still apply for adjustment of status through that immediate relative. So that's one exception to the general rule that you have to have legal status to apply for your permanent resident. There's another exception, and that's through VAWA. VAWA is the Violence Against Women Act, and it does not just protect or provide immigration relief to just women. It is for all genders. Hi there, and these genders would be a U.S. Your U.S. citizen, husband, a son as well, or a father. So not just women, but men as well. Now, what this relief requires you to show that you have been mistreated by a U.S. citizen or legal permanent resident. So in this case, you can have a legal permanent resident, spouse, a parent, if you're under 21 and unmarried, or a U.S. citizen, son or daughter, and they were mistreating you. If you were in a situation where they were verbally abusive, they were vindictive, they were doing things intentionally to be cruel against you, you could qualify for this form of relief that would allow you to get status in the United States. Even if you're out of status, it would allow you to stay in the United States and apply for your status here, your work permit, and your permanent residence. You would also get a path to U.S. citizenship if you made sure that you applied for adjustment of status and you got approved for the VAWA. So that is also a form of relief that you should keep in mind. If you're in a situation where you don't trust your relative, you're in an abusive situation like that, or you're even in the middle of your process with them, but it is a situation where you need to get out of it, you want to take control of your situation, VAWA would be the answer here. And then there are other humanitarian means. If you are the victim of labor trafficking, if you've been the victim and labor trafficking or sex trafficking, it means that you were brought here, or when you were here, you were coerced or you were convinced through fraud or you were straight up forced to do things against your will, whether to work or to do sexual acts. You were doing these things without your, you were not willing, but you felt like you had to do these things. Then this could be a trafficking situation, and you need to make sure that you follow up to get the legal advice as to whether you could qualify. If you've been the victim of a crime, a qualifying crime that resulted in your mental or physical abuse, like assault, domestic violence, stalking, robbery, these are only examples. It's not an exclusive list. But if you've been the victim of a crime, you could also apply for relief, obtain a work permit while you wait for your status in the United States. These can lead you to get permanent residence. So first you get the status, then you could possibly get your permanent residence. And these count even if you're out of status. There are still ways to get this status so that you can fix your situation and move forward in your life. And lastly, asylum. So if you are in fear of going back to your country because you're afraid that you're going to be targeted based on your identity, based on the fact that you're the member of a particular social group. So this could be based on your sexual orientation. This could be gender-based. If you are in fear of any kind of targeting like this, any kind of harm, whether you're going to be physically harmed, economically harmed, if you're going to be arrested, if you're going to be physically attacked or even killed, then you could qualify for asylum. That would help you to stay here. You would eventually be able to obtain permanent residence and then gain a path to citizenship. And this is in the case, there is a deadline unless you meet exceptions, but the deadline is you have up to 1 year after your entry into the United States to apply for this. Otherwise, you may lose your chance to apply. But even if you've passed that, there are ways to get by it if you can prove that there were some extraordinary circumstances that led to a delay or changed circumstances. That, in a summary, are ways to still gain status in the United States and a path to permanent residence if you are currently out of status. So if you would like to explore your particular situation, definitely get in touch. You can do that by going to the link in the profile. It's going to lead you to the website where you will see different options to go to the website to schedule your own appointment directly. Go ahead and do that because that's the best way you're going to get the personalized legal advice you need to determine whether you could pursue any one of these options. Once I determine you qualify, we get started right away to get your process going and get you the relief you need. Now, I am also here to answer questions as usual. So go ahead and put your questions in the comments and I will answer those questions. I'm both on YouTube, so I'm looking out for those questions on YouTube, and I'm on TikTok. So I see some comments here. I'm going to go through them here. Thanks so much for the love. I appreciate it. If you are charged with a misdemeanor, can you still apply for citizenship? That is a possibility. But in this case, it's so important. Can't stress enough for you to get legal representation, because some misdemeanors, remember, a criminal, when you are dealing with criminal issues, it's not a matter of it's a generic or a general type of legal advice. It's going to require analyzing the facts in your case to determine whether it's going to affect your eligibility. Something that may seem minor to you may be major and have major serious immigration consequences under immigration law. So no matter if it's a misdemeanor, you need to make sure that you understand fully the implications involved and then get legal representation to help you should you still qualify for citizenship. But what I can tell you now is it is a possibility. Whether you can do this is going to depend on the legal advice that you would get in a personal consultation. All right. So my girlfriend's father is applying for her. He apply for our son, which is grandson? It depends. So if she's over 21 or over, and she's applying through her father, she's unmarried, and she's applying through her father, who is a U.S. citizen or permanent resident, then the son could be included in that application. However, if she's under 21 and she is applying through her father as the immediate relative of a U.S. citizen, then no. In this case, her child would not be included. And I know this is a major problem in the immigration law. I think it's a big hole that can leave a lot of children leave the children behind when the parent gets to go. So it's gonna depend on what her age is and what category she's applying to, through her dad to get permanent residence. You're welcome, Anglices. Nice to see you. And thanks for the love. I appreciate it. All right. So I don't see any more questions here. So I am heading on over to Instagram to continue the conversation there. You're welcome to join me there. I am the immigration attorney, same as here, same as the YouTube channel, the immigration attorney. If you would like a recap of this live, you can always head on over to YouTube. I'm the immigration attorney on YouTube. So the channel is the immigration attorney, and you can check out the last video that's posted that will provide you a recap of what and not even a recap, a replay of this live, especially since I gave you a very, very quick summary of some of those categories that allow for one to apply or gain a path to permanent residence, even if they're currently out of status in the United States. You're gonna want to know this. All right, so I'll see you in a minute on Instagram on The Immigration Attorney, or I'll see you tomorrow at 4 p.m. Eastern Time, around 4 p.m. Eastern Time. I'll see you there. Remember, I'm here Mondays through Fridays, 4 p.m. Eastern Time. I bring a topic and you can bring your questions. So wife is forever inadmissible for false claim of citizenship while was tricked by unethical officer. So JJ Pace, that is definitely going to require a consultation since it's so specific. I would have to understand the facts involved to determine whether they would have some sort of recourse from that immigration charge. So if they were tricked, I would want to figure out what those circumstances are to determine whether there are any defenses or any arguments that could be made on behalf of your wife. I'm so sorry you're going through that. All right, so I'll see you on Instagram in a minute. If not, I will speak with you in a consultation. Have a great day. I'll see you tomorrow as well. Have a good one.